From distant lands we gather, hearts of fire all along. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big because we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Heyo, folks! Welcome to Saturday. What will it be? Saturday afternoon, Eastern Standard Time. It is evening here where I am, and good morning, you guys in Australia, Korea, Japan, Eastern Russia. Wherever you come from, good morning, good day, good evening, and hello. Today, Luigi Mangione, you know, the guy in New York who allegedly shot and killed the CEO for a company that denies people medical insurance coverage or whatever it is. It's a big case. It's a big case that I have not in itself that much interest in. What I have interest in is the things that are coming out now, like how his apprehension was actually done, what actually happened. And now his attorneys has come out with this allegation of a warrantless search. And if you know a bit about US law, that's a kind of a big thing. Warrantless searches, not being read Miranda rights, and all of that stuff. And that caught my interest. You would assume after, 40 years of Miranda rights, that cops knew how to do it. And even longer with this thing, you have to have some kind of warrant, unless, well, there are exceptions, of course. There are exceptions, of course. If it is an immediate threat, there's a bunch of exceptions. But was that the case when they actually apprehended him? So today we are going to read through the motion. Read through the motion. And here it is. Supreme Court of the State of New York, County of New York, the people of the State of New York versus Luigi Mangione. Notice of motion. All right, everybody ready? Yeah. This is 57 pages, so it might take a while, but I have time. Do you have time? I have time. Cheers. Please take notice that upon the annexed affirmation of Karen Friedman Agnifilo Esquire, sworn and affirmed on April 30th, 2025, Upon the indictment, the limited grand jury transcript that had been disclosed to the defense, supporting papers, discovery received thus far, and all proceedings herein, defendant Luigi Mangione will move this court for the following orders. This is what she asks of the court. Suppressing Mr. Mangione's statements to law enforcement as officers failed to provide him with Miranda warnings in violation of his Fifth Amendment rights. 2. Suppressing the evidence seized at the time of his arrest because law enforcement conducted a warrantless search of Mr. Mangione's backpack in violation of his Fourth Amendment rights after he was already handcuffed and surrounded by 10 police officers. 3. Precluding the District Attorney's Office from eliciting lay non-eyewitness identification testimony at trial. That would mean lay non-eyewitnesses identification testimony at trial, meaning people who weren't there and haven't shown up, who called in and said, "We think he's there," they can testify to it. 4. Dismissing the indictment's terrorism-related counts 1 and 2. Yeah, the terrorism charge is stupid, folks. It's stupid. It's just to get enhancements in order to get, I believe that's what they rest on when it comes to the death penalty. I think that is what it is. As the grand jury evidence failed to establish the required element that Mr. Mangione intended to intimidate or coerce a civilian population, influence the policies of a unit of government by intimidation or coercion, or affect the conduct of a unit of government by murder, assassination, or kidnapping. 5. Dismissing the indictment because concurrent state and federal prosecutions violate the double jeopardy clause, the 14th Amendment due process clause, and Mr. Mangione's constitutional rights against self-incrimination to meaningfully defend himself to a fair and impartial jury and to the effective assistance of counsel. And 6. Granting such other relief as the court deems appropriate. Now, point 5 here, that is a bit of a stretch. Now, I do believe he is charged both state and federal. I don't know if there's a general ban against that thing, but I don't think there is. Brooklyn says it wasn't a police bust, that they needed a warrant. He literally got caught in a McDonald's ordering food. Got caught doing what? They had a suspicion of him being Luigi Mangione. So what did he get caught doing in McDonald's? That's my question. Hiding, eating. But I assume we will go through this in this motion. Please take further notice that defendant Luigi Mangione reserves the right to file such additional motions as may be necessitated by additional discovery provided by the District Attorney's Office, the court's decision on this motion, or by further developments which, even by the exercise of due diligence, the defendant could not now be aware of. Yeah, because as I said up here, upon the indictment, the limited grand jury transcript. So his attorneys still haven't got the full transcript. And they're still working on discovery. Now, discovery will take a while. Let's see, respectfully submitted. Okay. And here comes the Karen Friedman Agnifilios affirmation in support of motion. Karen Friedman, the table of contents. Well, we don't need all of that. Well, overview, alleged facts, memorandum of law, dun dun dun. So we will just go through it here. Any questions? If you have questions, because as I read this, I am fully focused on the documents. So put the big red question marks with your questions. And if you really want me to read it, put it in a super chat. Now, those are never necessary. Those are appreciated, but never necessary. I'll just repeat a question if you think I haven't caught on to it. Karen Friedman Agnifilo, an attorney at law duly admitted to practice in the courts of New York State, affirms the following to be true under the penalty of perjury. I am an attorney and of counsel at Agnifilo, I can't pronounce that name, a law firm. She is the attorney for Luigi. Make this affirmation in support of a motion dated April 30th, seeking order suppressing Mr. Mangione's statement that were obtained in violation of his Fifth Amendment rights. I see here he was already wanted for arrest for murder. Yeah, so, does that mean that rights aren't violated? Now, can I determinedly say it has been? I don't know. That's why I want to read this motion. I haven't read this. If it's bullshit, I will tell you. If I think it's good, I will tell you. More probable, I will read the state's reply when it comes in, and then try to make a more make a better judgment out of it. Hey Ghosts, and hi Barb, hi Siobhan, hi Becky, hi you folks over here, hi Ambrosia and the rest over at Rumble, and hello you folks over at X. Good to see you. Good to see you. All right, let's continue here. Suppressing the evidence, yada yada yada, dismissing the terrorism. 2. This affirmation is made upon information and belief. The basis for such information and the ground for such belief are the indictment, incomplete grand jury transcripts, and exhibits, prior court proceedings, materials previously disclosed by the District Attorney's Office, information disclosed by the District Attorney's Office, and applicable legal authorities. Oh, thank you, Bart. Thank you so much. Gifting a membership. I'm deeply, deeply appreciated. It went to Denise Bax. Hey. Thank you so much. Oh, Mr. Jingles is here. Hello, Mr. Jingles. Hello. Overview. Okay, here's the basics. Overview. 377 people were murdered in New York City in 2024. Only one, however, the December 4th, 2024, shooting of United Healthcare CEO Brian Thompson, has led to a legal tug-of-war between state and federal prosecutors as they fight for who controls the fate of 26-year-old Luigi Mangione. As a result of unprecedented prosecutorial one-upmanship, Mr. Mangione now faces, this is a bit of hyperbole, but that's to be accepted. Not accepted, but expected. Mr. Mangione now faces 3 simultaneous prosecutions in 3 different jurisdictions, one of which is seeking the death penalty, while another is seeking life imprisonment, all for one set of facts. Yet, despite the gravest of consequences for Mr. Mangione, law enforcement has methodically and purposefully trampled his constitutional rights by interrogating him without Miranda warnings in violation of the Fifth Amendment and illegally searching his property without a warrant in violation of the Fourth Amendment. Siobhan says, yeah, that's why his team is arguing that's double jeopardy. I guess haven't read or watched about that motion yet. Yeah, we will see here. We will see if we get there. Compounding these constitutional violations, the District Attorney's Office has expanded New York's terrorism statute well beyond its legislative intent and its natural and legal definition to seek enhanced charges against Mr. Mangione, while also violating Mr. Mangione's rights against double jeopardy by simultaneously charging him alongside the federal government for identical alleged conduct. Critically, these concurrent prosecutions also violate due process and Mr. Mangione's constitutional rights to present a defense and not incriminate himself because the state and federal prosecution have conflicting theories. and Mr. Mangione's defense of one case could potentially be used against him in the other prosecution. As discussed below, concurrent state and federal prosecutions also violate Mr. Mangione's constitutional rights to a fair and impartial jury and to the effective assistance of counsel. Finally, forcing Mr. Mangione to defend himself in the instant case will remove rights afforded to him in the death penalty case. Well, the difference between life in prison and death penalty is the enhanced rights to discovery. We see that in the YNW Melly case. If they are seeking the death penalty, it allows a new set of rules. So, yeah, there is a difference between seeking life and seeking the death penalty. Mr. Jingles, folks, warn me if he does an only cats version of himself, and then so I can. I don't want him licking his private parts live on stream. Accordingly, Mr. Mangione requests that this court suppress his statements to law enforcement and the evidence illegally recovered without a warrant from his backpack. In addition, pursuant to People versus Mosley, discussed below, this court should preclude the district attorney from eliciting lay non-eyewitness identification testimony at trial. Mr. Mangione also requests that this court dismiss counts 1 and 2 of the indictment that rely on New York's inapplicable terrorism statute and are not supported by grand jury evidence. Lastly, Mr. Mangione also requests that this court dismiss the indictment because concurrent state and federal prosecutions violate the double jeopardy and due process clauses and limits his constitutional rights against self-incrimination to meaningfully defend himself to a fair and impartial jury and to the effective assistance of counsel. In the alternative, this is what they are actually seeking. This court can ameliorate these constitutional concerns by staying the state case while Mr. Mangione literally fights for his life in federal court. That is what they are actually seeking. They want the state case to be stayed until after the feds have done their thing. So that is what. Now, I could be wrong, but I've read hundreds of these. If you want to know what somebody actually is looking for, check in the alternative, and you will see we are really looking for this. So they aren't really looking for all the things, but at least stay the state case. Let us focus on the federal case. Sorry. Alleged facts. On December 4th, Mr. Thompson was shot outside the company's annual investor conference at the New York Hilton Midtown. Mr. Thompson, who had been subject to previous threats, died at a local hospital approximately 30 minutes later. Following the shooting, the NYPD released a video of the shooting and pictures of the masked suspect to the public. Within hours of the shooting, law enforcement also disseminated to the media and public that 2 of the discharged shell casing had the words "deny" and "depose" inscribed on them, and that the word "delay" was inscribed on a bullet recovered at the scene. The NYPD began a nationwide manhunt to search for the masked perpetrator and also enlisted the help of the public by posting a reward for information leading to his capture. The NYPD viewed thousands of hours of surveillance video to attempt to locate the shooter and where the shooter had been in the previous weeks. The NYPD police commissioner stated that they assigned 10 detectives from the NYPD's intelligence division to search through social media profiles of hundreds of young men who looked similar to the shooter and had also posted negative comments about the health insurance industry. Happy birthday week. Thank you so much, Catnot Williams. Thank you. Yes, it is my birthday weekend. Now, I can't specifically say which day it is, because Sweden has this thing with our social security number is based on date of birth and place of birth. So it's really stupid. Are we sprinkling? Do I have a sprinkling? I don't think I have a sprinkling. Do I have it? No, I don't have a sprinkling. Well, I don't know what you mean. Only toes or only claws. Yes, you are very good at cleaning yourself, Mr. Jingles. Yes, you are. Yes, you are. Thank you, Kat. Gifting 5 memberships to Lou Shods, Disney Nerd, Bree, Muffin Randall, and Lauren. Thank you so much, Kat. That is so nice of you. That is so nice. Oh, YouTube wouldn't let me gift one at a time. Oh no. Darn it. Oh, that's what you mean by doing one at a time? Oh, okay. Now I know what you mean with sprinkle. Hello, Mr. Dinos. All right, let's continue. On the morning of December 9th, 2024, Patrolman Joseph Detwiller and Tyler Fry of the Altoona Police Department responded to a McDonald's restaurant based on a 911 call of a quote-unquote suspicious male that looked like the shooter from New York City. Arriving at the McDonald's, the patrolman, both in full uniform and displaying badges, approached Mr. Mangione at 9:29 a.m. as he sat at the table in the back of the restaurant. As pictured below, Mr. Mangione was sitting at a corner table with a wall behind him, and to his left... Yeah. That's from a body cam at the scene. What do you mean, what's wrong with Mr. Jingles? There's nothing wrong with him. Last weekend, he had a fight with the neighbor's cat, and he won. Now, he did scratch his ear a bit, so he's being treated for it, but there's nothing wrong with him. Patrolman Detwiller and Fry positioned themselves to Mr. Mangione's right, blocking his only exit from the table, as he was already surrounded by 2 walls and a table. Patrolman Detwiller first asked Mr. Mangione to pull down his face mask and then asked for his name. Patrolman Detwiller told Mr. Mangione that someone had called the police because they thought he was suspicious. Both patrolmen were in uniform and fully armed. After Patrolman Detwiller asked to see Mr. Mangione's identification, Mr. Mangione is alleged to have provided a New Jersey license in the name of Mark Rosario. The patrolman asked Mr. Mangione if he was from New Jersey and whether he had been to New York recently. As Mr. Mangione prepared to eat his food, Patrolman Detwiller moved even closer to Mr. Mangione and asked him what he was doing in New York. Before Mr. Mangione even responded, Patrolman Detwiller asked him to stand up and put his hand on top of his head. Now, that is them technically only detaining him. It's the difference between detaining and arrest, and the line is different each time I hear a cop describe it. With Detwiller grabbing and lifting Mr. Mangione's right wrist above his head. Patrolman Detwiller asked Mr. Mangione why he was nervous. As Detwiller frisked Mr. Mangione. Now, here you are in the gray zone. Is he only detained or is he under arrest? Patrolman Detwiller ordered Mr. Mangione to sit back down at the table and directed Patrolman Fry to talk to Mr. Mangione, while Detwiller motioned for Fry to move physically closer to Mangione to reinforce Mangione's inability to leave. This is the attorney establishing because the less outs a person has, the more likely it is that it's considered he's being under arrest. Mr. Mangione was cooperative and complied with every request. As Patrolman Fry effectively had Mr. Mangione in custody. While he stood watched over him and blocked any potential exit, Patrolman Detweiler went outside to call another officer and tell him he was 100% sure that Mr. Mangione was the individual that law enforcement was looking for connected to the December 4th, 2024 shooting in New York. He did have an illegal weapon on him. Yes. Hence, was the search a legal search? He could have a nuclear bomb in there. And if the search is deemed illegal, it might as well not exist. So we can't have after the fact warrants, because that's not how this is supposed to be. Reasonable suspicion, everything leading up to, okay, you're under arrest. Because if they deem that this is an illegal search and things, poof, gone, we should be mad at the cops, because cops know in which order to do things. And imagine fucking up a death penalty trial because you were in a rush and didn't follow proper procedure. Imagine fucking things up that bad. When there should be absolute zero cops who doesn't know the correct procedure. Patrolman Detweiler returned to the back area of the McDonald's to further interrogate Mr. Mangione and asked if he was from New Jersey, what he was doing in Altoona, and whether he had been to New York recently. And Mr. Jingles is doing the Only Cats live on. Thanks. Every live stream, every single one. What he was doing in Altoona and whether he had been to New York recently. Even though Patrolman Detweiler had already decided that Mr. Mangione was the New York shooter, he told Mr. Mangione, as a pretext for the police interaction, that they were there because Mr. Mangione had been at the McDonald's for 40 minutes. Patrolman Fry remained in his strategic position, blocking Mr. Mangione's exit as Detweiler continued interrogating Mr. Mangione. Now, this is, again, the attorney trying to establish that already here, Mr. Mangione is to be considered under arrest. Which should mean that all the questioning should be, and every possible, if he answered, it should be inadmissible. I don't think the courts will agree that up to this point. This is just detained and asking questions, in my opinion. So, here you see it. Do I believe this is blocking all exits? We don't know, because Mr. Mangione never tried to leave. At 9:41 a.m., 12 minutes after they first approached Mr. Mangione, Patrolman Detweiler moved a backpack from the floor where Patrolman Fry had been blocking Mr. Mangione's path to an area far out of Mr. Mangione's reach. In the next minute, now, I think this is because if they start to take stuff from him, is that the line where a search? Did they have reason to believe that there was something exceptionally dangerous in that backpack? It's a matter for, I mean, for me, I would draw the line from, because backpack on the floor and all of a sudden they grab it. Is that an illegal search? Not yet, but now they have actively starting to remove things from him. Now he's blocked in, interrogated. They have been telling him, we believe you are that person. Brooklyn says he provided a false ID. That's where the crime occurred, in Pennsylvania. Okay. Then arrest him. Make it a proper arrest. Not this bad gray zone. The gray zones are... There shouldn't be a gray zone. If you are convinced, oh, this is Mr. Mangione, this is the person we are looking for, why not arrest him? Why draw it out to this ridiculous means? 5 additional uniformed and all officers entered the back area of the McDonald's where Mr. Mangione was detained and in custody. Patrolman Detwheeler ordered another officer to stand next to Patrolman Fry, forming an armed human wall, trapping Mr. Mangione at the back of the restaurant. As Detwheeler walked outside to talk with other officers to confirm that Mr. Mangione fit the description of the New York suspect. When Patrolman Detwheeler re-entered the McDonald's at 9:45 a.m., there were 3 patrolmen surrounding Mr. Mangione, and Mr. Mangione's backpack was approximately 6 feet away on a table. Notably, 2 of the patrolmen were positioned between Mr. Mangione and the backpack. Yeah, see that on that picture? At 9:46 a.m., with 8 officers now on the scene, another officer asked Patrolman Detwheeler if he had read Mr. Mangione his rights, as required by the Supreme Court's ruling in Miranda versus Arizona. Here comes something interesting. All of this is captured, by the way. When Patrolman Detwheeler responded that he had not, the officer told Detwheeler to tell Mr. Mangione that he was under official police investigation and to read Mangione his rights. Patrolman Detwheeler informed Mr. Mangione that was under official police investigation and that he would be arrested for false ID if he gave the police a false name again. Still without reading Mr. Mangione his Miranda rights, Patrolman Detwheeler continued interrogating Mr. Mangione. Now, here for me, you are on the wrong side of the gray zone. If another cop asks, have you read him his rights yet? That means a cop at the scene believes they have passed that line. You should read him his rights. Have you read him his rights yet? Detwheeler, by asking if his name was Marco Rosario, to which Mr. Mangione responded, no. Patrolman Detwheeler asked Mr. Mangione for his real name and his date of birth, which Mr. Mangione provided. Another officer at the scene asked Mr. Mangione twice why he lied about his name. At this time, there were 9 officers surrounding Mr. Mangione and blocking his exit from the McDonald's. For me, now we're on the other side of the gray zone. Can a court still say, it's still okay? Yeah, of course. Of course they can. Of course they can. And if a cop believes he's under arrest by saying, have you read him his rights yet? Then yes, I believe he was technically under arrest at this time. At 9:48 a.m., nearly 20 minutes after law enforcement first approached Mr. Mangione, prevented him from leaving and asked him numerous interrogation questions, Patrolman Stephen Fox finally read Mr. Mangione his Miranda warnings. After informing Mr. Mangione of his constitutional protected right to remain silent, Patrolman Fox asked Mr. Mangione if he wanted to talk to law enforcement. Mr. Mangione exercised his constitutional right to remain silent and expressed that he did not want to speak to law enforcement. That should end. Okay. Now everything is in a picture-perfect scene. Everybody stops talking to Mr. Mangione. They put him in cuffs. Everything that is his is put in evidence bags for further investigation, getting the warrants, getting everything. Oh, thank you, Bob. With a celebrating pair super sticker. Thank you so much. That is so nice of you. Thank you so much. Hello, everybody. Hello, Slider Pie over at Rumble, and again, hello, you guys over at X. Good to have you here. Mr. Mangione expresses that he did not want to speak to law enforcement. Patrolman Fox told Mr. Mangione that he was not in custody at this point. Which means what? But that is double wording. Not in custody could mean, yeah, you are now under arrest. But claiming he is not in custody, at this point is just stupid. It's clear that he is in at least custody. So my interpretation of this is that the cop says, you're no longer in custody because you are under arrest. His Miranda warnings has been read. He has exercised his rights. You can't go back and unarrest somebody. Despite the fact that at the moment there were 10 officers in the back of the McDonald's where Mr. Mangione was sitting, they already decided with 100% certainty that he was the shooter, and he was clearly in custody and not free to leave. Patrolman Fox then asked Mr. Mangione why he had a fake ID. After Mr. Mangione did not answer, Patrolman Fox ordered Mangione to stand and put his hands on the wall so Fox could pat him down. He's clearly under arrest here, in my personal opinion. If you disagree, I don't mind. As long as you constructive criticism is welcomed here. And Staley said, well, the sequence is detained, detention, then arrest. Well, you can't really, he's held there under suspicion, he's detained. He's then read his Miranda rights, and then somebody tells him he's not detained. Yeah. Or not, he was not in custody at this point. That's just stupid. Fox put his hand on the wall, pat him down, to which Mr. Mangione complied in all respects with these directives. At 9:50 a.m., approximately 90 seconds after telling Mr. Mangione that he was not in custody, despite being surrounded by officers, and after he'd been patted down twice, Patrolman Fox handcuffed Mr. Mangione and thoroughly searched him again. I mean, now it's just getting overkill here. If it is as the lawyer expresses here, and there is body cam of it, everything here tells me they have passed the line of you're under arrest long ago. Mr. Mangione remained standing, handcuffed and surrounded by the officers as they waited for verification of his identification. Yeah. Mr. Fox, Patrolman Fox, claiming he's not in custody. Don't be voluntarily stupid. Don't be voluntarily stupid. At 9:54 a.m., Patrolman Detwheeler walked out of the McDonald's to discuss Mr. Mangione's identification with another officer. During this conversation, and without any explanation, Patrolman Detwheeler covered his body-worn camera with his hand to prevent the camera from recording 20 seconds of his conversation. Why, Mr. Detwheeler? What? You have to have known this was throughout the United States, everybody was checking in what's going on with this case. Why stupid? Why stupid? At 9:58 a.m., several officers began searching through Mr. Mangione's jacket and pockets and frisked him again. At the same time, Patrolman Chrissy Wasser Wasser, and Patrolman Fox began searching through the backpack law enforcement has placed on a table out of Mr. Mangione's reach more than 17 minutes earlier. Now, the big point of discussion here is, did they have... Now, normally, you need a warrant. Were they under any of the exceptions? Were they under any exceptions? As part of these warrantless searches, Patrolwoman Wasser opened Mr. Mangione's backpack and fully searched the backpack, its compartments, and its contents, including closed bags that were within the backpack, while Mr. Mangione stood handcuffed and surrounded by officers who were positioned between Mr. Mangione and his backpack. Yep, there you see her in the background, searching through the backpack, while Mr. Mangione is handcuffed and everything. As part of this warrantless search, Patrolman Fox retrieved a small item from inside the backpack that was enclosed in cardboard and wrapped in tape. Patrolman Fox took out his knife and sliced open the tape to find a computer chip inside. Why do stupid? He is under arrest. He's clearly under arrest. Why the rush? Why the rush? The entire backpack into an evidence bag to be opened and searched with a warrant in the precinct. You would have gotten the warrant on the way to the precinct. Why the rush? Why? Why the rush? The officers continued their warrantless search through Mr. Mangione's backpack at McDonald's, even after he was removed from the restaurant by other officers and driven to the precinct. During this continued search at McDonald's, Patrolwoman Wasser recovered a gun magazine loaded with bullets. Now realizing she had made a potentially devastating mistake by thoroughly searching the backpack of a murder suspect in a significant New York press case without a warrant, she suddenly stated that she was searching through the backpack at McDonald's to make sure there wasn't a bomb or anything in there. You can't say that after the fact. You say it before. You ask the question to the person in charge at the place, should we make a search for a bomb or something? And if it is affirmative from the person in charge, that, yeah, it might be. He might be a terror. I mean, still stupid, but not after the fact. Not after.
You stupid woman!
Why so? Yeah, I salty. See, that's a crazy statement. Yeah. Before putting the backpack in the car. The falsity of that comment was made clear seconds later when another officer at McDonald's stated, quote, now that we found the, i.e. the loaded magazine, let's just bring it back to the precinct. Suddenly not concerned about a bomb. How about that? Patrolwoman Wasser placed all the items back into the backpack and stopped searching. Patrolwoman Wasser repeated a comment that she was making sure there were no bombs in the backpack. Ladies and gentlemen, or whatever you identify yourself of, if you have an actual suspicion there might be a bomb in the backpack, what do? You call the fucking bomb squad. But if you're scared of a bomb in a backpack, Do you just rip it up and start rumbling around? No! You call the bomb squad. Oh, hi, Fun Size. Happy birthday, Nick Storrow. Thank you so much. Thank you so much. Daly says, I thought we had discussed this. In many, if not all jurisdictions in the States, you are literally not allowed to be a cop if you are too intelligent. Yeah. The backpack was no longer in the suspect's control or proximity, and there were multiple officers between him and it. There was no reason to suspect that suspect a bomb. No, Now, does this mean that the court will take this into consideration? They might. They actually might, because this is so stupid. Here's something else. Yeah, I should have continued. As another officer commented that, quote, at this point, we probably need a search warrant for it. So somebody at the scene knew, oh, we should have had a search warrant before we did this. Without calling for the bomb squad, as you should if you actually suspect a bomb, evacuating the McDonald's, or even searching for a bomb, patrolwoman Wasser placed the backpack in a police car and brought it to the precinct. Nobody suspected a bomb. Not one. Not a single one. It's that, oh, I fucked up. I need to come up with something really, really fast here. There might be a bomb in there. Patrolwoman Wasser left McDonald's at 10:04 a.m. There is no body-worn camera footage from her for the next 11 minutes as she drives to the precinct with the backpack. At 10:16 a.m., 1 minute after arriving at the precinct, Patrolwoman Wasser continued her warrantless search of the backpack. She continues. Patrolwoman Wasser first reopened the same backpack compartment that she had started searching at the McDonald's before immediately closing that compartment and opening the front compartment of the backpack as if she was specifically looking for something. Instantly, she, quote-unquote, found a handgun in the front compartment. After finding the gun at the precinct, Patrolwoman Wasser again explained to another officer that she quickly searched the bag at McDonald's to make sure there were no bombs or anything. Patrolwoman Wasser did not explain why she did not seek a warrant once she had arrived at the precinct. Patrolwoman Wasser continued to search the backpack at the precinct without a warrant and recovered a silencer, a red notebook containing Mr. Mangione's personal writings, additional writings, a computer chip, an iPhone, and several USB flash drives. Over 7 hours after the warrantless search of Mr. Mangione's backpack, the Altoona Police Department finally sought a search warrant at 5:14 p.m. The warrant application sought permission to search and seize the items from Mr. Mangione's backpack that law enforcement had already searched several times and seized earlier that morning. Hey, Cat. This Cat says, this reminds me of the Acorn cop. He continued to say he was shot in his leg to justify his panic that the suspect, while cuffed in the back of his patrol car, somehow fired a shot at him. Yeah. 7 hours later. Mr. Mangione was formally arrested and charged in Altoona with forgery, possession of a weapon and tampering with records or identification, possession of an instrument of a crime for possessing a silencer, and furnishing a false identification to a law enforcement officer. Hello, Mr. Nichols. Hello. On December 17th, 2024, the New York County District Attorney's Office publicly announced that Mr. Mangione had been charged by a grand jury in an 11-count indictment alleging the following crimes. 1. Murder in the first degree. 2. Murder in the second degree as a crime of terrorism. 3. Murder in the second degree. 4. Criminal possession of a weapon in the second degree. 5. Criminal possession of a weapon in the second degree. Okay. 6. Criminal possession of a weapon in the third degree. 7. Criminal possession of a weapon in the third degree. 8. Criminal possession of a weapon in the third degree. 9. Criminal possession of a weapon in the third degree. 10. Criminal possession of a weapon in the fourth degree. And 11. Criminal possession of a forced instrument in the second degree. 2 of these charges, murder in the first degree, count 1, and murder in the second degree as a crime of terrorism, count 2, rely on the terrorism statute under Article 490 under the penal law. John C. says, I'm not sure why a warrantless search would be needed. He was apprehended in the act. In the act of what? Well, the state will probably argue the fake ID. Is a fake ID enough to search everything on a person? Because if he is under the suspicion of murder, why just not wait? Why not just wait? Why claim you're not in custody while 10 officers are there, you are up against the wall and patted down 3 times? I'm having a hard time. It seems like if a cop at the scene also says we probably need a warrant for that, they needed a warrant for that. If a cop at the scene says, have you read him his Miranda rights yet? Then you already passed the line of, yeah, he's under arrest. If a cop at the scene does this. Blah, 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 blah. During a press conference by the Manhattan District Attorney and the NYPD Police Commissioner announcing these charges, there were no mention whatsoever of any federal case. On December 19th, after waiving extradition to New York, Mr. Mangione was transported via procession in a fleet over a dozen police cars and then flown via plane and helicopter to New York City from Pennsylvania. Yeah, I covered the perp walk. It's embarrassing. It's absolutely embarrassing. They claimed they needed all of that because security, and then the mayor of New York just walked up. Yeah, that's stupid. Later that morning, counsel was on the way to this court for a previously arranged afternoon Supreme Court arraignment before Mr. Mangione could be brought to this court for his planned state court arraignment. The FBI unexpectedly seized custody of Mr. Mangione and brought him to the Southern District of New York, where he was charged by federal complaint filed the night before, charging Mr. Mangione with stalking, 2 counts, murder through use of a firearm, and a firearms offense. These charges are based on the same facts and evidence as the New York State indictment. Mr. Mangione was remanded to federal custody at the Metropolitan Detention Center in Brooklyn, where he is currently still detained. Yeah, folks, yes, I know a murder is very, 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 very serious. And since he was caught in another state with the alleged murder weapon and everything cross-state, technically, it then falls under the feds. Technically. On December 23rd, Mr. Mangione was produced to this court and was arraigned on the pending indictment. 37. To date, the District Attorney's Office has produced more than 1 terabyte of information in discovery. Notably, the District Attorney's Office has withheld additional discoverable materials, including portions of the grand jury testimony. Why? Why? If everything is a clear-cut case, there's no reason to withhold grand jury testimony. There's no reason. On April 1st, 2025, the United States Attorney General directed the Southern District of New York prosecutor to seek the death penalty. On April 17th, 2025, the federal prosecutors formally indicted Mr. Mangione for the charges listed in the federal complaint. On April 24th, the federal prosecutors filed a notice of intent to seek the death penalty, and on April 25th, Mr. Mangione was arraigned in federal court. Memorandum of law. Mr. Mangione's statement to law enforcement must be suppressed because they were unconstitutionally obtained through interrogation without Miranda warnings while Mr. Mangione was in custody. This piece here is unclear. Where do you draw the line? Where do I draw the line? Oh, well, before a cop at the scene drew the line, in my opinion. New York law is clear. A defendant's statements obtained through custodial interrogation without Miranda warnings should be suppressed. People versus Corey. Vacating the defendant's plea where the trial court failed to suppress the portions of the defendant's statements made without prior Miranda warnings while in custody and in response to police questioning. People versus Dorville. Under these circumstances, the defendant was improperly subjected to custodial interrogation without being advised of his Miranda rights, requiring suppression of those statements. People versus Crawford, noting that the hearing court erred by not suppressing the defendant's pre-Miranda statement that were the product of custodial interrogation. People versus Davis, when, as part of a continuous chain of events, a defendant is subjected to custodial interrogation without Miranda warnings, any statement made in response, as well as any additional statements made after the warnings are administered and questioning resumes, must be suppressed. So they have a bunch of law here. They have a bunch of law here. And we are on page 20 out of 57. We are going to be here a while. And thank you for being here. Thank you for being here. That's very nice of you. In assessing the admissibility of Miranda-less statements, courts must determine 1, whether the police questioning constituted interrogation, and 2, whether the defendant was in custody. People versus Cabrera. Miranda warning must be administered when an interrogation occurs after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. Deprived of his freedom of action in any significant way. Well, folks, they blocked every chance of Mr. Mangione's he had no outs. I'm having issues with my internet for some reason. Hold on here. If you lose sight of me, just let me know. Quoting Miranda v. Arizona, 1966. Oh, Jesus Christ, that's 59 years ago, the Miranda. 59 years ago. 41. For Miranda purposes, interrogation refers to any questioning or actions by law enforcement officers that are reasonably likely to elicit an incriminating response from a suspect. People versus Pullman. The term interrogation under Miranda refers not only to express questioning, but also to any words or actions on the parts of the police other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit an incriminating response. 42. In this case, when Patrolman Det Wheeler initially approached Mr. Mangione, he already believed that he was the New York shooter. When asking Mr. Mangione if he had been to New York recently, Patrolman Det Wheeler was seeking to elicit an incriminating response. This question was obviously important enough that Patrolman Det Wheeler asked it numerous times, including after telling another officer that he was 100% sure that Mr. Mangione matched the New York suspect. In asking this question, Patrolman Det Wheeler knew it was likely to elicit an incriminating response because there was nothing about their interaction or being in McDonald's that related to New York other than the shooting. Yeah. If they didn't believe or had a reasonable suspicion to believe that Mr. Mangione was the shooter, the ID was why the ID would never have been shown. So, but it's all about where do you draw the line? Where do you draw the line? The standard for when someone is considered in custody is met here as well. The standard for assessing a suspect's custodial status is, quote unquote, whether a reasonable person, innocent of any wrongdoing, would have believed that he or she was not free to leave. People versus Pullman. Quote, the test is not what the defendant thought, but rather what a reasonable man, innocent of any crime, would have thought had he been in the defendant's position. So this means you ask yourself, how many cops surrounding where you are, surrounded by two walls and a table, at what point are your liberties infringed? At what point do you think for yourself, I can't go anywhere? So that is a question you have to ask yourself if you believe you are a reasonable person. Here, there can be no doubt that Mr. Mangione was in custody when interrogated by the police. When first approaching Mr. Mangione, Patrolman Det Wheeler and Fry deliberately and strategically positioned themselves in a way to prevent Mr. Mangione from leaving from the back of the McDonald's. In addition, before walking out of the McDonald's, Patrolman Det Wheeler made certain to position Patrolman Fry close to Mr. Mangione to prevent his exit. Patrolman Det Wheeler also directed other armed officers where to stand in order to limit Mr. Mangione's movements. From the time they first approached Mr. Mangione, the officers intentionally placed themselves in such a way to ensure Mr. Mangione could not leave. By intentionally blocking Mr. Mangione's ability to move past them, the patrolman made clear to Mr. Mangione or anyone else who was in his position that he was not free to leave. Mr. Mangione's inability to leave was made even clearer when additional armed officers entered McDonald's and positioned themselves to prevent him from leaving. An objective person in Mr. Mangione's position would also have believed that he was not free to leave because the significant uniformed armed police presence in the McDonald's was disproportionate with Patrolman Det Wheeler's statement that the police were there because Mr. Mangione has been sitting at the McDonald's for 40 minutes. It's not illegal to sit at the McDonald's for 40 minutes, to my knowledge. A trivial offense such as loitering or trespass would not require such a significant police reaction. No, one would show up, you need to leave. Out you go. Rather, the number of officers at the McDonald's limiting his movement would indicate to any objective person that the officers were there to prevent him from leaving. See People versus Pabon. Under the circumstances of this case, a reasonable innocent man in the defendant's position surrounded by 6 police officers, albeit is in his home, would have considered himself in custody. Here they were 10. People versus SS. The police officers surrounded the defendant as he stood outside the apartment. the defendant's freedom was restricted to the hallway, and the police activity conveyed the impression the police had decided to arrest the defendant. Despite Mr. Mangione's inability to leave, Patrolman Death Wheeler continued to question Mr. Mangione without Miranda warnings, even after another officer instructed Patrolman Death Wheeler to inform Mr. Mangione that he was under official police investigation and to read Mr. Mangione his rights. That's the question from we read that about a half hour ago. A patrol officer said, "Shouldn't we read his Miranda rights?" So even cops at the scene thought they should read the Miranda rights. Moments later, another officer asked Mr. Mangione twice why he lied about his name, all while being surrounded by 9 uniformed police officers blocking Mr. Mangione's exit from McDonald's. Because law enforcement violated Mr. Mangione's Fifth Amendment rights while he was in custody, counsel moves to suppress all statements Mr. Mangione made to law enforcement between December 9th, 2024 and December 19th, 2024. Why? All the footnote, all of these statements are listed as statements 1 to 34 in District Attorney's CPL. Okay, that's why. In the alternative, this court should conduct a hearing pursuant to People v. Huntley to determine whether law enforcement obtained Mr. Mangione's statements in violation of his Fifth Amendment rights. So this is what they actually assert. They ask, suppress it, or at least have a hearing, meaning we want a hearing. B. All evidence recovered from Mr. Mangione's backpack must be suppressed because law enforcement failed to obtain a search warrant before searching the backpack. Okay, there is a bit of contention here. I see it in the chat and stuff like that. But here we at least will see what law and what examples in the case law will Mr. Karen Friedman move forward with. All blah, blah, blah. Legal standard for warrantless searches in New York. Altoona law enforcement failed to follow fundamental Fourth Amendment case law and basic police procedure by failing to obtain a search warrant before searching through Mr. Mangione's backpack and the closed containers within the backpack. Police conducted this warrantless search even though there were no exigent circumstances, as Mr. Mangione was already in handcuffs. The backpack was on a table over 6 feet away, and Mr. Mangione was separated from this table by a wall of armed officers. As conducted by body-worn camera footage, the entire search of the backpack was done well after it was secured and moved far from Mr. Mangione's grabbable area. What's a grabbable area? Don't answer that. Please don't answer that. The Fourth Amendment protects individuals from unreasonable searches and seizures by the government. U.S. Constitution, Amendment 4. Building on the Fourth Amendment's protections, the New York Court of Appeals has ruled that, quote, warrantless searches presumptively are unreasonable per se, and thus, where a warrant has not been obtained, it is the people who have the burden of overcoming this presumption of unreasonableness. People versus Jimenez, quotation and alterations omitted. Okay. While New York courts have accepted a search conduct by law enforcement, quote, incident to a lawful arrest as an exception to the warrantless requirement, the prosecutors must first satisfy 2 separate requirements. Quote, the first imposes spatial and temporal limitation to ensure that the search is not significantly divorced in time or place from the arrest. The second, and equally important, predicate requires the people to demonstrate the presence of exigent circumstances. Jimenez, also People v. Gokay. Under the state constitution, an individual's right of privacy in his or her effects dictates that a warrantless search incident to arrest be deemed unreasonable unless justified by the presence of exigent circumstances. So here, what were the exigent circumstances? And I suppose that's why the cop said, oh, I'm looking for a bomb. Why a bomb? It was a shooting. Not why yeah. It shows me that officer knew what they needed, but she didn't express, oh, I'm looking for a bomb, until after she actually started to search the backpack. And again, if they actually believed there was a bomb, you call the fucking bomb squad. The exigent circumstances requirement for searches incident to a lawful arrest specifically applies when law enforcement searches closed containers. Also the Jimenez case. Quote, in the context of warrantless searches of closed containers incident to arrest, the people bear the burden of demonstrating the presence of exigent circumstances in order to invoke this exception to the warrant requirement. When addressing the exigency requirement for a warrantless search incident to a lawful arrest of property within the defendant's quote-unquote immediate control or quote-unquote grabbable area, the Court of Appeals has recognized, quote, two interests that may justify the warrantless search of that property incident to a lawful arrest: the safety of the public and the arresting officer, and the protection of evidence from destruction or concealment. Goki and Morales. The Court of Appeals has recognized two interests underlying the exigency requirement: the safety of the public and the arresting officer, and the protection of evidence from destruction or concealment. People versus Julio. A bag is within the immediate control or grabbable area of a suspect at the time of his arrest, may not be subjected to a warrantless search incident to arrest unless the circumstances leading to the arrest support a reasonable belief that the suspect may gain possession of a weapon or be able to destroy evidence. After seeing the pictures, is there any reason to believe that Mr. Mangione could get a hold of that backpack? I don't think so. Nevertheless, because the search incident to a lawful arrest exception to the warrant rule requires exigency, and here's from Morg, a container may not be searched for a weapon or evidence if it is apparent that it is so securely fastened that the person arrested cannot quickly reach its contents, or the person arrested makes unmistakably clear that he will not seek to reach the contents of the container is so small that it could not contain a weapon or evidence of the crime. So either the container is so small so it's not reasonable to believe there's a weapon there, or he cannot reasonably reach it to get a hold of a weapon. Becky says, I'm looking for a bomb probably has worked in the past for these cops. Yeah, I would assume so. People versus Smith. Ruling that the police did not need a warrant where, quote, at the time of arrest, defendant was holding the briefcase in his hand. Its contents were therefore readily accessible to him, and it was of sufficient size to contain a weapon. Yeah, he actually, that guy held on to his briefcase. Similarly, quote, even a bag within the immediate control or grabbable area of a suspect at the time of his arrest may not be subjected to a warrantless search incident or to the arrest unless the circumstances leading to the arrest support a reasonable belief that the suspect may gain possession of a weapon or be able to destroy evidence located in the bag. Surrounded by 10 cops. Bag was at another table. Let's see here. People versus Jimenez, Washington. We find that the trial court should have suppressed the 12-inch knife recovered by the police during a warrantless search of defendant's bag. Although at the time of the search, the bag was on the floor within the grabbable area next to defendant. He was standing with his arm handcuffed behind his back. These circumstances do not support a reasonable belief that the defendant could have either gained possession of a weapon or destroyed evidence located in the bag. In Mangione's case, the bag is 6 feet away. There are 10 cops surrounding him, and he's being patted down. Internal go case citation omitted. People versus Houston. Suppressing evidence recovered from the warrantless search of the defendant's briefcase that he placed on a parked car when he surrendered, because even though the police had found a loaded gun on the defendant's jacket pocket when they arrested him, the police failed to establish exigent circumstances to search the briefcase. Footnote 7. Oh, that's a lot. Finding exigent circumstances to search the defendant's wallet, even though the defendant was handcuffed because the wallet was within his grabbable area and had not been reduced to the executive control of the police, and because the officers had reason to suspect that the wallet might contain a weapon because the defendant had been arrested for robbery, a violent crime, and the officers had already recovered one razor blade from the defendant. Denying suppression where the bag was in appellant's grabbable area and the police opened the bag almost simultaneously with handcuffing appellant. Okay. 55. Moreover, a search incident to a lawful arrest is not justified, and suppression is proper when the defendant's backpack is, quote, not within the defendant's immediate control or grabbable area at the time he was arrested. See People versus Thompson. Suppressing a semi-automatic gun recovered from the defendant's backpack because the search, quote, was not justified as a search incident to a lawful arrest, as the, quote, backpack was not within the defendant's immediate control or grabbable area at the time he was arrested. Ta fucking da. People versus Diaz. Warrantless search of the defendant's backpack was unlawful because the defendant was handcuffed at the time of the search and it was no longer in his control. People versus Julio. Warrantless search of the defendant's bag was unlawful where it was in the exclusive control of the police and the defendant was unable to reach it because he was handcuffed and surrounded by police officers. I'm not entirely sure at what point Mr. Mangione was handcuffed, but it was definitely not in its grabbable area, and there were 10 cops surrounding him. If he had bolted for his bag, he would have been dead. Let's just say that. People versus Morales is particularly instructive. There, a police responded to a 911 call of a suspicious man inside a restaurant who appeared to be trying to steal from women's purses. After exiting the restaurant with the police, the defendant placed both of his hands in his jacket pockets, leading to a struggle between the officers and the defendant when the defendant refused to remove his hands from his jacket pockets. The 7 officers at the scene subdued the defendant, handcuffed him, and placed him in a police car. While the defendant sat handcuffed in the back seat, officers searched his jacket that had fallen onto the trunk of the police car during the altercation and found drugs and a box cutter. In reversing the lower court and dismissing the indictment, the First Department found that, quote, at the time of the search, the jacket was not within defendant's grabbable area, and there was no exigent circumstances justifying a warrantless search of the jacket incident to arrest. So if the courts did not find this to be enough, when he was actively struggling, more or less, they found him during the commission of a crime, not false ID, armed robbery, not false ID, armed robbery. And if that case says, not have to throw it out, well, it all seems to come down to when was he under arrest. 58. Notably, in suppressing the evidence, the First Department rejected the dissenting judge's argument that the search was, quote, was justified because the jacket may have contained a loaded gun that would endanger the police and the public, end quote, because, quote, even if there had been a legitimate concern at some earlier time during the encounter between defendant and the police that the defendant might retrieve a weapon from the jacket, that possibility no longer existed at the time the police conducted the search. So whatever was in Mr. Mangione's bag, he can't get a hold of it. And if you actually suspect a bomb, you call the fucking bomb squad. What did they do? Or what did they? They did not call the bomb squad. So claiming I have to search just in case there's a bomb, I have to say I don't find that legitimate. The First Department further noted how the dissent's argument was not consistent with New York case law. Taken to its logical conclusion, the dissent is arguing that an exigency that may have existed earlier in the encounter allowed the police to search the jacket, even where the jacket was in the exclusive control of the police. That view, if accepted, would run afoul of Court of Appeals jurisprudence and would eviscerate the grabbable area doctrine. And here, folks, in this case, Mr. Mangione was over there. In between there's cops. Here's the bag. And what happened? Well, the female officer took control of the bag and then started searching it. So, meaning it was in their control. Mr. Mangione had zero ability to reach his bag. Now, we still have to wait for the state's response because everything we read here is, of course, by default to Mr. Mangione's favor. Everything we read here is towards his favor. When the state files a response, I will read it just as I do here. I will read it cold turkey, not skimming through it before. I will read it live for you. And then but as it is written now, I think they should suppress it. And all of a sudden, they don't have a gun. They don't have a manifesto. Imagine that. Being so fucking stupid that you risk a murder case just because you're curious. Let's continue. The dissent would extend this doctrine and hold that whenever there is the possible presence of a weapon, the police can search a container to protect themselves, even if it is nowhere near the suspect's grabbable reach. Such a conclusion finds no support in this state's jurisprudence on searches incident to arrest. 2. There were no exigent circumstances allowing law enforcement to search Mr. Mangione's backpack without a search warrant. There can be no disagreement that at the time law enforcement started searching Mr. Mangione's backpack, he was in handcuffs, okay, and surrounded by police officers, while the bag was approximately 6 feet away from him. Moreover, even before Mr. Mangione's arrest, the backpack was not within his immediate control or grabbable area because Patrolman Death Wheeler had quickly moved it to another table approximately 6 weeks away, roughly 9 minutes earlier. And there was a human wall of police officers strategically standing between Mr. Mangione and the backpack. In addition, even before the arrest, the scene was police controlled as there were 10 or more officers in the back of the McDonald's. Nevertheless, despite the lack of any exigency, officers began searching through his backpack while inside McDonald's. There was certainly no exigency once Mr. Mangione was removed from McDonald's. Yet law enforcement continued to search the backpack in the restaurant without a warrant. Under New York law, this search was illegal and the contents of the backpack must be suppressed. Now, let's speculate. Let's say the court say, we will suppress this piece of evidence. What will the prosecutors do? Well, they will do the loophole. They would have found it anyway, through other means. He was going to be arrested. He was going to do bump, and then a search warrant was held up. But so there's probably a loophole in there somewhere. And I assume the state, once they file their report or their reply, they will say what that loophole is. 60. The fact that they believe that Mr. Mangione was the person wanted for murder does not change the analysis nor provide the necessary exigency to overcome this fatal police error. First, the shooting happened 5 days earlier, and the police had no reason to believe that the alleged shooter was still armed. Well, that's a stretch. That's a stretch. Second, even if the police had reason to believe he may be armed, any exigency disappeared after patrolman Death Wheeler frisked Mr. Mangione for weapons, moved the bag 6 feet away, and had armed officers strategically placed between Mangione and the backpack. The exigency was certainly removed once Mr. Mangione was handcuffed and surrounded by officers. Morales case, quote, we fail to grasp the logic of the dissent's position that any such danger did not disappear simply because defendant had been subdued. In fact, it did disappear. Defendant was locked in the police car and the jacket was on the trunk. Once defendant was safely separated from the jacket, the record does not show that any harm could have resulted from the possible presence of a weapon. And as you said earlier, that is why they say there could be a bomb. She didn't believe it was a bomb in there. If they actually believe there's a bomb in a backpack, evacuate, bomb squad. So that's just, yeah, stupid. Furthermore, there certainly was no exigency once Mr. Mangione was removed from McDonald's or once patrolwoman Wasser brought the backpack to the precinct. By continuing to search the backpack, even outside of Mr. Mangione's presence, the police underscored that the search had nothing to do with exigency and was simply searching for incriminating evidence. Yeah, I mean, why the fucking rush? Why the rush? If you actually believe you have him, bring the big evidence bag, stuff the backpack in the big evidence bag, bring it back, have all the bells and whistles and dots and I's and everything, and do it the correct way. Why the fucking rush? While patrolman woman Wasser claimed that she was searching the backpack to make sure there was no bomb inside, this post hoc excuse, after the fact excuse, did not reflect any legitimate exigency. First, nothing about the alleged shooting in New York or law enforcement's interactions with Mr. Mangione in the McDonald's provided a reasonable basis to believe that there was a bomb in the backpack. Second, the patrolwoman did not make this claim until after she had already been searching through the backpack and after she recovered a loaded magazine. Tellingly, she stopped searching the backpack at the McDonald's once she recovered the loaded magazine. If one were legitimately concerned about a bomb, one would have either continued searching right then and there, or cleared the McDonald's and have called in and waited for the bomb squad to arrive before searching the bag. Neither of which occurred. Dave says, you don't need a warrant if the government says it's okay. Yeah. It's always that. Certainly, one would not have continued searching the bag in a McDonald's filled with officers, employees, and customers, or put the bag in their car to transport the potential bomb to the precinct. Third, that an officer sliced open a small taped-up cardboard container too small to house a bomb is further evidence that this was a warrantless search for evidence rather than a legitimate concern about a bomb. Fourth, this police theory, claiming exigency without more, would render all high-profile murder cases exigent by this standard, as there is always the theoretical possibility of a bomb inside a closed backpack. Under New York law, however, quote, exigency is not demonstrated unless it's supported by circumstances giving rise to an objectively reasonable suspicion. People versus Diaz. Rather, all these circumstances demonstrate that Patrolman Wasser did not search the bag because she reasonably thought there might be a bomb, but rather this was an excuse designed to cover up an illegal warrantless search of the backpack. This made-up bomb claim further shows that even she believed at the time there were constitutional issues with her search, forcing her to attempt to salvage this debacle by making this spurious claim. Yep. Nor can the search be justified as an inventory search. As the Court of Appeals has noted, quote, an inventory search is exactly what its name suggests. A search designed to properly catalog the contents of the item searched. Here, the officers were not inventorying or cataloging the contents of the backpack at McDonald's. That is clear from the fact that the officers did not write down what they were removing from the backpack. Coupled with the fact that officers put the loaded gun magazine back in the backpack once they found it and stopped searching altogether. And this is the Johnson case, 256. It can hardly be said that the officer in this case followed the policy for inventory search by conducting a search that included only the glove compartment and upon finding a gun, leaving it in place. So there is case law. 65. What the officers were doing instead was rummaging through the backpack looking for evidence. Such conduct is not proper inventory search and is prohibited by the Supreme Court and New York law. Florida v. Wells. An inventory search must not be a ruse for a general rummaging in order to discover incriminating evidence. The policy or practice governing inventory searches should be designed to produce an inventory. The individual police officer must not be allowed so much latitude that inventory searches are turned into a purposeful and general means of discovering evidence of crime. And the Johnson case, as the Supreme Court has stated, an inventory search must not be a ruse for general rummaging in order to discover incriminating evidence. 66. Because the officers had no basis for their warrantless search, the recovered evidence must be suppressed. 3. Sorry, I need to... The legally obtained evidence recovered from Mr. Mangione's backpack is not admissible under the doctrine of inevitable discovery. Oh, this is the loophole I think the state will go for. As the warrantless search was illegal, the district attorney has no basis to claim that the recovered evidence should nevertheless not be suppressed because the evidence would have been inevitably discovered when the police conducted an inventory search of the backpack at the precinct. In New York, the Court of Appeals has established that the doctrine of inevitable discovery does not apply, quote, where, as here, the evidence sought to be suppressed is the very evidence obtained in the illegal search, because permitting its admission in evidence affects what amounts to an after-the-fact purging of the initial wrongful conduct, and it can never be claimed that a lapse of time or the occurrence of intervening events has attenuated the connection between the evidence ultimately acquired and the initial misconduct. The illegal conduct and the seizure of the evidence are one and the same. People versus Smith. The Court of Appeals further noted that admitting illegally obtained evidence through the inevitable discovery rule, quote, that would amount to a post hoc rationalization of the initial wrong. Another quote, would be an unacceptable dilution of the exclusionary rule and would defeat a primary purpose of that rule, deterrence of police misconduct. Additionally, failing to exclude wrongfully obtained primary evidence would encourage unlawful searches in the hope that probable cause would be developed after the fact. Quoting the Oregon Court of Appeals in State versus Crossan. Consequently, because the doctrine of inevitable discovery is inapplicable to primary evidence, i.e. the very evidence obtained in the illegal search, there is no basis to admit the illegally searched evidence from Mr. Mangione's backpack. People versus Stiff and People versus Julio. The people's alternative argument that evidence of the gun should be admitted under the inventory exception ignores the fact that the exception is only applicable to secondary evidence. It is inapplicable in the circumstances at bar where the evidence of the gun is primary evidence, i.e. the very evidence obtained in the illegal search. The likelihood that the gun would have been discovered during an inventory search at the police station therefore does not vitiate an illegal search and seizure. Since the search of the bag was unlawful, the evidence of the gun must be suppressed. That is from the Julio case. They are really, really quoting the Julio case here. 4. Mr. Mangione has standing to challenge the illegal search of his backpack. Because this backpack was in Mr. Mangione's possession when stopped by the police at McDonald's, as shown on the body-worn camera footage, Mr. Mangione had a reasonable expectation of privacy in his closed backpack and standing to challenge the unlawful police search. People v. Burton. Standing exists where a defendant was aggrieved by a search of a place or object in which he or she had a legitimate expectation of privacy. This burden is satisfied if the accused subjectively manifested an expectation of privacy with respect to the location or item searched that society recognizes to be objectively reasonable under the circumstances. Additionally, Mr. Mangione also has standing to challenge the search of his backpack by relying on the district attorney's allegations and evidence that the backpack and its contents belong to Mr. Mangione. See GJTR at 148. I moved on with Officer Wasser to search his backpack on an adjacent table. 156. The backpack that Mr. Mangione had on him. So yeah, they acknowledge that it is his backpack. People versus Ramirez Portorial. In sum, standing to seek suppression of evidence requires the defendants to establish by defendant's own evidence or by relying on people's evidence that he or she had a legitimate expectation of privacy in the place or item that was searched. For these reasons, the court must suppress all evidence obtained from the backpack, including but not limited to the gun, the silencer, and Mr. Mangione's alleged writings, electronic devices, and any evidence obtained as the fruit of the illegally obtained evidence. In the alternative, and here we go to what they really want, this court should conduct a hearing pursuant to a map. Well, if they can get a suppression without it, sure. Pursuant to map v. Ohio, to determine the admissibility of this evidence after considering the appropriateness of law enforcement conduct. C. The district attorney's office should be precluded from eliciting lay non-eyewitness identification testimony at trial. The district attorney's office has notified counsel that it intends to offer 3 law enforcement witnesses at trial to make an in-court identification of Mr. Mangione. For these 3 witnesses, NYPD Detective Oscar Diaz, Patrolman Joseph Detwheeler, and Patrolman Fry, the in-court identification will be grounded on an identification of the defendant from video surveillance based on said individual's familiarity with the defendant. The district attorney's office cites to People v. Coleman in support of its proposed in-court identification by law enforcement witnesses. The prosecutor's reliance on this case is misplaced. However, as the Coleman court ruled that the lower court erred in admitting testimony from 2 police officers and the defendant's aunt to establish that the defendant was the individual depicted on the surveillance video of the alleged incident. Yeah, I call this narration. Oh, yeah, that's definitely the defendant on that video. That is a question for the jury and nobody else. Having a person saying, that's him. No, that is always up to the jury, in my opinion. Dun, dun, dun. Coleman. In finding this evidence improper, the First Department noted that while a lay witness may offer an opinion about the identity of a person captured in a photograph or videotape to aid the jury in cases where the witness is more likely to correctly identify the person than is the jury, such testimony is most commonly allowed in cases where the defendant has changed his or her appearance since being photographed or taped, and the witness knew the defendant before that change of appearance. Because the prosecutors never claimed that the defendant altered his appearance, and there were no other circumstances suggesting that the jury, which had ample opportunity to view the defendant, would be any less able than the witnesses to determine whether he was seen in the videotape. The court ruled that the evidence should not have been admitted. This issue was also recently addressed by the New York Court of Appeals in People v. Mosley, where the court ruled that the trial court abused its discretion by admitting a police officer's testimony identifying the defendant as the shooter in camera footage. The Court of Appeals framed the issue as follows. This case concerns an increasingly prevalent issue. When may someone who is not an eyewitness to a crime testify to a jury that the defendant is the person depicted in a photo or video? We hold that such testimony may be admitted where the witness is sufficiently familiar with the defendant that the testimony would be reliable, and there is no reason to believe the jury might require such assistance in making its independent assessment. Here, there was no showing that the proffered witness was sufficiently familiar with the defendant to render his testimony helpful, or that the jury faced an obstacle to making the identification that the witness testimony would have overcome. The facts in Mr. Mangione's case demand the same result. Here, the proposed witnesses are not eyewitnesses to the crime. Moreover, the witnesses had no interactions with Mr. Mangione prior to the video surveillance to make them sufficiently familiar with Mr. Mangione. Noting that courts may also take into account whether the witness was familiar with the defendant's appearance at the time the surveillance footage was taken. Additionally, there is no allegation that Mr. Mangione altered his appearance after the alleged shooting, and there is no reason to believe that the jury would need any assistance in making its own assessment of the video surveillance footage. Accordingly, the district attorney should be precluded from seeking an in-court identification of Mr. Mangione where the witness identification is based on viewing video surveillance. Moreover, based on Mosley, the district attorney's witnesses should also be precluded from testifying that Mr. Mangione is the individual depicted in a photo or video. In the alternative, these courts should conduct a Mosley hearing to determine the admissibility of the proposed lay non-eyewitness identification testimony. From the Mosley case, we note that before admitting lay non-eyewitnesses identification testimony, a court should inquire as to the basis of the witnesses' familiarity outside the presence of the jury in a separate hearing or voir dire, as the court properly did here. The party offering the witness, in most cases the people, bears the burden of establishing that their testimony would both be helpful and necessary. D. The indictment first-degree murder charge, count 1, and second-degree murder as a crime of terrorism charge, count 2, must be dismissed because the grand jury evidence fails to establish intent to intimidate or coerce a civilian population as required by statute. Applying New York terrorism statute to this case would impermissibly trivialize and redefine the legislature's definition of terrorism. They are bringing up 9/11 here. In the weeks after, and because of the September 11th, 2001, terror attack on New York City, New York State passed its first ever state terrorism law in the response. The Anti-Terrorism Act of 2001 passed 6 days after the attack in a special session of the state legislature. By enacting this law, the New York legislature looked to strengthen New York law to ensure that, quote, terrorists are prosecuted and punished in state courts with appropriate severity. People versus Morales. The legislative history and the context within which this law was passed demonstrate that this law was only intended to apply to a very narrow category of the most serious offenses, and only when they meet a certain criteria similar to the following terrorist attacks: the 9/11 attack, the bombing of the American embassies in Kenya and Tanzania, the Oklahoma bombing, the Pan Am flight in Lockerbie, the 1997 shooting from Empire State Building, the 1994 murder of Ari Halverstam on the Brooklyn Bridge, and 7, the bombing at the World Trade Center in 1993. The New York Court of Appeals has cautioned against the improper use of this powerful tool, warning that, quote, the concept of terrorism has a unique meaning and its implications risk being trivialized if the terminology is applied loosely in situations that do not match our collective understanding on what constitutes a terrorist act. Now here Mr. Mangione's writing kind of speaks against it, but I'm not sure. This warning was ignored by the district attorney's office when they indicted Mr. Mangione for first-degree murder under the theory that the victim was, quote-unquote, killed in furtherance of an act of terrorism, as well as second-degree murder as a crime of terrorism, despite there being absolutely no facts to support this theory. To seek these enhanced charges, the district attorney's office alleges that Mr. Mangione's actions meet the terrorism standard under penal law, blah, 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 and penal law, blah, 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 because his actions, quote, were intended to intimidate or coerce a civilian population, influence the policies of a unit of government by intimidation or coercion, and affect the conduct of a unit of government by murder, assassination, or kidnapping. This is not the first time a prosecutor's office had tried to fit the square peg of a murder into the round hole of terrorism. People v. Morales is one example of such prosecutorial overreach. In that case, the defendant was an alleged gang member who shot numerous times at a rival gang member, paralyzing the rival, but hitting and killing a 10-year-old girl. Morales, 20 NYD, blah, blah, blah. The Bronx County District Attorney's Office indicted the defendant on 70 counts, including several crimes that relied on New York's terrorism statute. In support of the terrorism charges, the prosecutors claimed that the goal of the defendant's gang was, quote-unquote, to be the most feared Mexican gang in Bronx, and that the defendant's actions were intended to, quote, intimidate or coerce all Mexican Americans in the pertinent geographical area. The defendant was convicted of several crimes, including 3 crimes that relied on the terrorism statute. The defendant appealed his conviction, and the Appellate Division, First Department, found that there was insufficient evidence proving that the defendant intended to intimidate or coerce a civilian population because the evidence, quote, established that defendant only engaged in gang-related street crimes, not terrorist acts. Oh. On appeal, the Court of Appeals started its analysis by noting that the terrorism statute failed to define the phrase, quote, intend to intimidate or coerce a civilian population, end quote. The court noted, however, that it was not necessary to define the term civilian population to resolve the case because, inter alia, even if the evidence established that one of the defendant's goals was to intimidate or coerce the rival gang, quote, there is no indication that the legislature enacted Article 490 of the penal law with the intention of elevating gang-on-gang street violence to the status of terrorism, as that concept is commonly understood. The Court of Appeals further noted the statutory language cannot be interpreted so broadly so as to cover individuals or groups who are not normally viewed as terrorists. And the legislative findings in Section 490 clearly demonstrate that the legislature was not extending the reach of the new statute to crimes of this nature, as apparent in the examples of terrorism cited in the legislative findings. Because the legislature was aware of the difficulty in defining or categorizing specific acts of terrorism, it incorporated a general definition of the crime and referenced 7 notorious acts of terrorism that serves as guideposts for determining whether a future incident qualifies for this nefarious designation. Finding the defendant's conduct did not meet the criteria for terrorism enumerated by the legislature, the Court of Appeals ruled that the terrorism statute did not apply to the shooting. I don't have any more sodas, so I'm grabbing a beer. It's almost 11 p.m. where I am. It's Saturday. I'm having a beer. Cheers. Daily Quick Bites. John C. asks if you can unblock him. Just because he doesn't see your he doesn't see you in the chat. Check if you are in live chat mode, because you see more there than. Okay, let's continue. Other courts have followed suit. Followed that the terrorism statute did not apply where a student threatened the victim, another student, that the victim would be chopped up into somebody's backyard, and that the student was going to get a white person to shoot up the school because there was no evidence that the student intended to intimidate or coerce a civilian population. The de Blasio, finding the terrorism statute did not apply where the defendant, a Muslim, threatened to shoot you guys, referring to several Bangladeshi worshippers at defendant's mosques after an altercation, and there was no evidence that the defendant intended to intimidate or coerce a civilian population because, quote, the threat mentioned no group or population and instead appears to have been used on a personal dispute the defendant had with one or more of his fellow worshippers over money or a missing phone. When viewed in this context, the New York legislature did not intend for the crime of terrorism to include Mr. Mangione's alleged conduct, a shooting directed at a single individual. As the terrorism examples the legislature referenced were attacks on multiple civilians. And then they quote all these cases where at least one dead and several injured. Because the alleged conduct here does not meet the legislator's use of the term terrorism, counts 1 and 2 that rely on the terrorism statute must be dismissed. The grand jury evidence failed to establish that Mr. Mangione intended to intimidate or coerce a civilian population. In addition to not fitting the legislator's terrorism profile, there is also no credible evidence before the grand jury supporting the use of terrorism statute. Penal law, define an act of terrorism as an act that is intended to, we already went through that. Although the language in count 1 and 2 of the indictment lists all 3 theories, there was no evidence presented to the grand jury demonstrating that Mr. Mangione's actions were intended to influence the policies of a unit of government by intimidation or coercion, affect the conduct of a unit of government by murder, assassination, or kidnapping, as Brian Thompson was not part of any governmental unit. The only remaining theory, therefore, is that Mr. Mangione intended to, quote-unquote, intimidate or coerce a civilian population. But even that theory is not supported by the grand jury evidence. The only reference to a civilian population in the grand jury is the testimony of a United Healthcare employee who referred to United Healthcare employees as civilians. As an initial matter, the term civilian population cannot be read so broadly in the terrorism statute to include the roughly 400,000 United Healthcare employees around the country. They have that must be 400,000. That have to mean 40,000. There can't be 400,000 United Healthcare employees. I have to check. Yeah, wow. 400,000. How can they have 400,000 employees? All right. If that's what it says, that's what it says. All right. After all, as noted above, the legislative findings surrounding the New York terrorism statute demonstrate that the statute intended to address terrorist acts similar to the acts listed by the legislature. As noted by the First Department in its Morales opinion, it suffices to observe that the term to intimidate or coerce a civilian population in the context of the aforementioned legislative findings implies an intention to create a pervasively terrorizing effect on people living in a given area, directed either to all residents of the area or to all residents of the area who are members of some broadly defined class, such as gender, race, nationality, ethnicity, or religion. It wasn't healthcare employees, maybe healthcare insurance CEOs. The rich are protected. People v. Morales, noting that the intention by a gang member to intimidate members of rival gangs when not accompanied by intention to send an intimidating or coercive message to the broader community does not, in our view, meet the statutory standard. These defined classes, gender, race, nationality, ethnicity, religion, or the like, were not meant to include employees of a health insurance company. In other words, while the term civilian population in the context of terrorism statute may include the general population in a given area or specific identifiable segments of the population in a given area, it was not meant to include every potential group of individuals who have something in common. Moreover, although the Court of Appeals noted that the term civilian population could conceivably range from the residence of a single apartment building to a neighborhood, city, county, state, or even a country, it does not follow that the Court of Appeals endorsed the view that any group of individuals, no matter how broadly defined, would constitute a civilian population under the terrorism statute. In fact, the Court of Appeals warned what would happen if prosecutors sought to broadly define the term. If we were to apply a broad definition to, quote, intent to intimidate or coerce a civilian population, the people could invoke the specter of terrorism every time a blood assaults a crip or an organized crime family orchestrates the murder of a rival syndicate soldier. But the concept of terrorism has a unique meaning, and its implications risk being trivialized if the terminology is applied loosely in situations that do not match our collective understanding of what constitutes a terrorist act. History and experience has shown that it is impossible for us to anticipate every conceivable manner in which evil schemes can threaten our society. Because the legislature was aware of the difficulty in defining or categorizing specific acts of terrorism, it incorporated a general definition of the crime and referenced the 7 notorious acts of terrorism that serves as guideposts for determining whether a future incident qualifies for this nefarious designation. Even assuming the term civilian population could include United Healthcare employees, the grand jury evidence was still insufficient to support the terrorism charges in the indictment. Person 93 testified that United Healthcare workers received threats after December 4th shooting, that some employees were afraid, and that the company told its employees not to publicly wear clothing with the company logo. This testimony, however, has no relevance on the element on whether Mr. Mangione intended to intimidate or coerce a civilian population. This evidence only shows how others, including United Healthcare itself and its employees, responded to the shooting. It does not provide any insights into what Mr. Mangione himself intended, which is a necessary element of the terrorism statute. Additionally, this evidence fails to consider, as was presented to the grand jury, that United Healthcare and its employees had received threats prior to December 4th, 2024. The district attorney also seems to rely on Mr. Mangione's alleged writings to establish his intent to intimidate or coerce a civilian population. Notably, as none of the alleged writings reference any other United Healthcare and employees, the only civilian population referenced in the grand jury, these writings do not establish the necessary element that Mr. Mangione intended to intimidate or coerce a civilian population. Moreover, this alleged writings makes clear that Mr. Mangione was not looking to terrorize any community. Noting that Ted Kaczynski was a monster and terrorist, the worst thing a person can be, by indiscriminately mail bombing innocents. ID, bomb equal terrorism, because it's recklessly endangers countless employees. As such, these writings cannot be the basis to support the finding that he intended to intimidate or coerce a civilian population. In fact, they support just the opposite. Additionally, because these alleged writings were never released by Mr. Mangione to the public, nor were they intended to be, these private writings do not support the allegation that Mr. Mangione intended to intimidate or coerce a civilian population. They quote the Allen case from 2020. While a private conversation between teenage friends without more may not establish the element of intent to intimidate a civilian population, the instant case does not qualify as a private conversation. Rather, by selectively releasing these writings to the public and affixing the term manifesto, a law enforcement term, not one ever used by Mr. Mangione, law enforcement is responsible for causing the very public intimidation or coercion they are now trying to attribute to Mr. Mangione, which is the basis for charging him with enhanced terror-related charges. Notably, manifesto is defined by Merriam-Webster as, quote, a written statement declaring publicly the intentions, motives, or views of its issuer. There is absolutely no evidence that Mr. Mangione ever either publicly released or intended to release the writings that law enforcement attribute to him. Therefore, the only ones who ever published the writings were law enforcement. Similarly, Mr. Mangione never called these writings a manifesto, as this a term was first coined by law enforcement to characterize the writings with a phrase synonymous with terrorism in order to prejudice Mr. Mangione. Furthermore, to the extent the district attorney seeks to support the terrorism-related charges by arguing that Mr. Mangione allegedly inscribed the words deny, delay, and depose on bullets recovered at the scene, these facts do not demonstrate that Mr. Mangione intended to intimidate or coerce United Healthcare employees, the only civilian population referenced in a grand jury, or anyone else for that matter. Notably, law enforcement announced that these words were inscribed on the bullets, not Mr. Mangione. If Mr. Mangione intended to intimidate or coerce a civilian population, he would have publicly disseminated that he had written those words on the bullets, but he never did. Instead, as with Mr. Mangione's alleged writings, law enforcement strategically leaked this information to the public, causing any fear they are attempting to attribute to Mr. Mangione. Oh, thank you, Ghost. 400,000 employees are globally, includes UHC plus subsidiaries. Thank you. Thank you. It is worth noting that this case would have looked like without law enforcement purposefully leaking information to the press and social media. This would have been an alleged murder of a man outside of a hotel. Instead, the police leaked what was written on the bullets, the police leaked Mr. Mangione's alleged writings, and the police called these alleged writings a manifesto, a term synonymous with terrorism. None of this was done by Mr. Mangione. It was law enforcement that created the air of terrorism surrounding this alleged crime, and who now seek to blame Mr. Mangione for the hysteria and fear they caused. Without sufficient evidence that Mr. Mangione's actions were intended to intimidate or coerce the civilian population, he influenced the policies of a unit government by intimidation or coercion, or affect the conduct of a unit of government by murder, assassination, or kidnapping, this court must dismiss count 1 and 2 of the indictment. Now, would that mean that he is off on no, that means he's only going to be charged with normal murder and normal second-degree murder. And then you will go into the double jeopardy clause. Ow. The concurrent state and federal prosecutions violate the double jeopardy clause and Mr. Mangione's constitutional rights because the prosecutions have conflicting theories, and Mr. Mangione's defense of one prosecution could potentially be used against him in the other prosecution in violation of his Fifth and Sixth Amendment rights. While this case is unprecedented in many ways, the most troubling feature of this multi-jurisdictional prosecution for the same shooting is that the federal and state prosecutors are seeking to prosecute Mr. Mangione at the exact same time for the exact same act, with the federal government seeking the death penalty and the state prosecutors seeking life imprisonment. Moreover, although these are simultaneous prosecutions, state and federal prosecutors have both indicated that they intend for the state case to proceed to trial first. This situation, and this goes to my understanding is that death penalty case, if they seek the death penalty, you have the right to extended discovery. But if they go for the state case first, that means they can withhold a lot of things from the defense. You hear that in the YW Melly case. The judge there has said on numerous occasions to the prosecution, hand it over, you sought the death penalty, Mr. Melly has extended discovery rights. This situation is rare in that, unlike the few historical concurrent state and federal death penalty cases, in which the state prosecution is always either stayed or dismissed, or the federal death penalty case is brought only after the state case is resolved, here Mr. Mangione is being forced to fight two cases simultaneously for the identical act at the exact same time. For example, in the case of Peyton Gendron, he was charged by state and federal prosecutors for the May 2022 racially motivated shooting that killed 10 African Americans in Buffalo, New York. In November 2022, while the federal case was pending, but before the federal government sought the death penalty, Mr. Gendron pleaded guilty to the New York charges and was sentenced in February 2023 to 11 life sentences without the possibility of parole. Only in January of 2014, these years are odd. Only in January 2014, that must mean 2024. Nearly a year after Mr. Gendron was sentenced on the state case, did the federal government seek the death penalty. As such, Mr. Gendron was never facing state charges when the federal government was seeking the death penalty. Another example is Robert Gregory Bowers, who was charged by state and federal prosecutors for the 2018 Pittsburgh synagogue shooting that killed 11 Jews. Soon after the federal government announced its prosecution that carried the potential death penalty, the state prosecutors agreed to hold the state case in abeyance until the federal case was completed. Accordingly, Mr. Bowers never had to face a concurrent state prosecution while his federal death penalty case was pending. The same is true for Zohar Tsarnaev, who was charged in federal court and faced the death penalty for the Boston Marathon bombing, blah, 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 blah. As described more fully below, the legal quagmire the concurrent state and federal prosecution have created make it legally and logistically impossible to defend against them simultaneously without effectively admitting to the federal death penalty charge. This situation is so constitutionally fraught that we are hard-pressed to find precedent for such an unprecedented situation. The closest precedent we could find for simultaneous prosecutions involve when both jurisdictions are seeking the death penalty, thus affording the same rights and protections to the defendant in both cases. For example, in the case of Dylan Roof, he was charged in both state and federal courts for the 2015 case that killed 9 African Americans in South Carolina. In those cases, Mr. Roof was charged in both federal and state courts with capital offenses, and both cases proceeded concurrently, with the federal trial proceeding to trial first. In 2016, Roof was convicted in federal court and sentenced to death in January 2017. Soon after 2017, Roof pleaded guilty to the state charges to avoid a second death penalty sentence. He was sentenced in April 2017 to 9 consecutive sentences of life without parole. In contrast, without this court's intervention, Mr. Mangione will be forced to defend his federal death penalty case while at the same time defending against this state prosecution seeking life imprisonment. A truly unprecedented and untenable situation. Even worse, in addition to concurrent prosecution, the Manhattan District Attorney's Office wants their less serious case to go first. These concurrent prosecutions raise several considerable constitutional concerns. First, the state and federal prosecutions relate to identical facts. By charging Mr. Mangione in both state and federal courts, prosecutors are trying to get 2 bites at the apple to convict Mr. Mangione. Even more troubling is that the 2 bites the prosecutors are seeking are for the death penalty and life imprisonment. This is what the Fifth Amendment's double jeopardy clause is meant to prevent by providing that, quote, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. U.S. Constitution Amendment 5. While the prosecution will respond that the double jeopardy rules does not apply here because the state and federal governments are separate sovereigns, that doctrine has been subject to relentless criticism by members of the bench, bar, and academy. Campbell v. United States. Ginsburg dissenting. Moreover, a free society does not allow its government to try the same individual for the same crime until it's happy with the result. New York has long recognized this principle and indeed precluded this very concept when it codified CPL 40-20, prohibiting a person from being prosecuted for the same offense twice. In fact, the defendant was prosecuted in federal court and either convicted or acquitted, the state would be precluded from bringing their successive prosecution. They should not therefore be permitted to bring this case based on identical facts merely because there has not yet been a final judgment federally. This court should not allow that to happen here, and certainly not where the potential results are the death penalty and life imprisonment. We are on page 49, folks. We are soon there. We are soon there. Second, in addition to double jeopardy concerns, concurrent prosecutions here also violate Mr. Mangione's constitutional rights to defend himself and not to incriminate himself, as he is charged with conflicting prosecutions theories that may prevent Mr. Mangione from defending one without implicating the other. For example, the dueling theories of these two concurrent prosecutions create a scenario where, in defending against New York's terrorism-related charges, Mr. Mangione could not argue that his alleged conduct was targeted toward one individual rather than a civilian population, without then incriminating himself in the federal case that charges him with stalking that one individual. This scenario would preclude Mr. Mangione from the ability to waive his Fifth Amendment rights and testify on his own behalf, as by doing so, Mr. Mangione could be providing the federal government with evidence that would be used against him in their prosecution. Both the district attorney's office and the federal prosecutors, including the acting United States attorney under the previous administration, have publicly stated that they have agreed that the state case would proceed first. By prosecuting both cases at the same time, and by agreeing that the state case would proceed to trial before the federal case, without any input from this court, the federal judge presiding over the federal case or the defendant, the state and federal prosecutors are in essence colluding to obstruct Mr. Mangione's ability to meaningfully defend himself, a right guaranteed under the Sixth Amendment and the 14th Amendment's due process clause. Mr. Mangione's inability to meaningfully defend himself is made even more serious by the fact that the Attorney General of the United States has directed the prosecutors in the Southern District of New York to seek the death penalty against Mr. Mangione, the most serious punishment available, while the District Attorney's Office is seeking life imprisonment, the most serious punishment allowable in the state. Allowing the state prosecution to proceed on trial first would violate Mr. Mangione's constitutional right to defend himself and would force him, despite his presumption of innocence, to choose between the scalia of life imprisonment and the charbis of death penalty in order to meaningfully defend himself. Third, should Mr. Mangione be convicted first in a highly publicized state prosecution, it would be impossible for him to find a fair and impartial jury in his subsequent federal trial, where he is still presumed innocent and facing the death penalty. This is particularly true in this case because the evidence in both trials will be nearly identical, given that both prosecutions are based on the same exact facts, and both prosecutions will rely heavily on police work done by the NYPD. By forcing Mr. Mangione proceed first in a public state court trial, all of the evidence will be discussed in the news and social media for weeks and possibly months before Mr. Mangione starts his federal death penalty trial, making it impossible for Mr. Mangione to get a fair and impartial jury, as guaranteed by the Sixth Amendment and the New York State Constitution. Whew. Fourth, concurrent prosecution will also negatively affect Mr. Mangione's right to counsel. Because death is the most serious penalty facing a criminal defendant, defense counsel in death penalty cases must be able to properly focus on the pending capital case. Having a concurrent state prosecution, at the same time seeking life imprisonment, limits counsel's ability to properly focus on the federal death penalty case. For example, death penalty cases require more robust motion practice than non-death penalty cases, as the docket of federal death penalty cases are replete with motions challenging the imposition of the death penalty, given the specific facts of the case and the unique characteristics of the individual defendant. One recent example is Saipov, who was facing the federal death penalty in U.S. v. Saipov for killing 8 civilians in October 2017 by driving a flatbed truck into the pedestrian pathway on the west side of Lower Manhattan. In defense of Mr. Saipov, his attorney filed the following motions relating to the death penalty. Motion to preclude the government from seeking the death penalty. Motion to dismiss specific aggravating factors from the government's notice of intent to seek the death penalty. Yeah, all of these. Notably, these motions were in addition to the usual motions that defense counsel filed in a federal crime case, including a motion to dismiss charges, a motion to suppress evidence, motions in limine, and a motion for a judgment of acquittal. All of these motions practice in complex and time-consuming, yet necessary when a defendant is on trial for his life. Having concurrent estate case with its own complicated motions and pre-trial hearings will limit counsel's ability to focus sufficiently on the death penalty case. In addition to more robust motion practice, federal death penalty cases also require a significant mitigation investigation into the defendant's life. As the Supreme Court has noted, defense counsel in a death penalty case, quote, should comprise efforts to discover all reasonable, available, mitigating evidence and evidence to rebut any aggravating evidence that may be introduced by the prosecutor. That is because the jury must consider the defendant's life as, quote, part of the process of inflicting the penalty of death. And in this other case, we have held that the state cannot preclude the sentencer from considering, quote, any relevant mitigating evidence that the defendant proffers in support of a sentence less than death. In this case, to meet constitutional requirements, a death penalty statute must not preclude consideration of relevant mitigation factors. In another case, a process that accords no significance to relevant facets of the character and record of the individual offender or the circumstances of the particular offense excludes from consideration in fixing the ultimate punishment of death, the possibility of compassionate or mitigating factors stemming from the diverse frailties of humankind. It treats all persons convicted of a designated offense not as uniquely individual human beings, but as members of a faceless, undifferentiated mass to be subjected to the blind infliction of the penalty of death. This required mitigation investigation is tremendously time-consuming. It includes a social history investigation that requires the painstaking collection and analysis of objective, reliable documentation about the client and his family, typically including medical, educational, and employment records. The collection of multi-generational records for the client and his family, including his parents, grandparents, siblings, and cousins, and analysis of this documentation involve a slow and time-intensive process. Mitigation also includes in-person interviews of family members, neighbors, educators, and friends who may have important information to share about the defendant's history and characteristics. It takes time to build rapport with these individuals so that they feel comfortable sharing their personal insights. Because of the tremendous amount of work and effort required to defend the death penalty case, as well as the more complicated legal issues involved, it generally takes several years from indictment to trial in a capital case. For example, although Peyton Gendron was indicted federally in July 2022, his death penalty trial is not scheduled to start until September 2025, more than 3 years after his indictment. Similarly, Saipov was indicted in November 2017. His federal death penalty trial, however, did not start until January 2023. Bowers took also 5 years. These constitutional issues described above arise if Mr. Mangione is forced to proceed first with the state trial. Justice and common sense therefore dictate that a federal case with a more serious penalty of death should proceed first. This is what often occurs in an analogous situation when a defendant is facing both criminal and civil proceedings at the same time relating to the same matter. The court presiding over the civil proceeding will often stay the civil proceeding pending the completion of the more serious criminal matter. Given the concerns with how concurrent criminal and civil proceeding may implicate a defendant's Fifth Amendment rights against self-incrimination, both state and federal law allow courts to stay civil proceedings in this situation to prevent prejudice. I don't think that is it. Yeah, civil proceeding with civil proceedings. That's money, not life. I don't think this is a good analogy. To the extent courts see the wisdom in staying in civil proceedings while there are a pending criminal matter, this court should appreciate Mr. Mangione's unprecedented situation and concomitant constitutional concerns and allow the death penalty case to proceed first. We raise this issue now to comply with the court's motion schedule. We note that the federal prosecutors recently filed their notice of intent on April 34th, 2025, to formally seek the death penalty. Now that a potential death sentence is in play, Mr. Mangione has constitutional and statutory rights not afforded to non-death defendants. We also note that counsel has recently filed motions in federal court to preclude the government from seeking the death penalty. This motion practice is continuing before the Honorable Margaret Garnett in the Southern District of New York. Because the death penalty issue is ongoing, we respectfully request the ability to supplement this motion with additional facts and law relating to the concurrent state and federal prosecution and how the state case may affect Mr. Mangione's rights as a defendant facing the death penalty in federal court. Conclusion. This court is all that stands between justice and Mr. Mangione being forced to stand trial against illegally obtained evidence, terrorism-related charges that had no application to the alleged shooting of one man, and concurrent prosecutions that violate the double jeopardy clause and his constitutional rights. For the reasons stated above, we respectfully request that this court grant the requested relief. Respectfully submitted, Karen Friedman Agnifilo, Mark Agnifilo, Jacob Kaplan. Counsel for Luigi Mangione. What do I take with me from this? Well, I think that the police who arrested Mr. Mangione fucked up seriously. And that the female officer who started the search and then all of a sudden, oh, I'm just looking for a bond. It actually should be thrown out. Because even if this is an extremely serious case, I would assume that this is how these cops act in less serious crimes as well, where they don't have 10 cops at the scene, where there might only be one cop at the scene, but then rummages through the backpacks and belongings to a suspect just to find the evidence, and then go back to the precinct, write the affidavit, and then look through the things again. So that is, so my opinion, when it comes to the suppression of the evidence, I actually think they should, based on this motion alone, based on this. Now, I have to read the state's reply when it shows up, because this motion here is solely in Mr. Mangione's favor. Solely. Need to read the state's reply first, but based solely on Mr. Mangione's statements, or Mr. Mangione's attorney's statements, should it be inadmissible? Yeah. Not because it's not a serious crime, it's because we can't allow cops to fuck up this bad. We can't. It's bad cop work. And we need the cops to do better. And evident by the actions of the officers at the scene, they knew better. All of them. They chose to not do better. But I have to wait until the state's reply. I expect it to show up quite soon. And when it does, I will do a similar reading as I did here to you guys. And hopefully we get answers to some of the questions we have here. Hopefully. Never know, but hopefully. Let's see here. Let's see if Vice Baby is still on. Or if he eating if he eating the oh, he's still on. Great. So I'm going to send you over to him. Dun, dun, dun. If I can send you over to him, I don't know that yet. Yeah, I can. All right. So I will. Everybody, thank you. Thank you for showing up. Thank you for allowing me to do these kind of things. If you agree with me, say so. If you disagree with me, tell me to fuck off, but do it constructively. Okay? All right. I'm going to send you over to Vice Baby, and then I will probably join them there. And then Monday, the trial against Christopher Schur continues. For you who are fed up with the Karen Reed case, the Schur case is white cop shoots black suspect in the back of his head, claims self-defense. It's an interesting case. Again, everybody, thank you so much, and I will see you Monday. Okay? Bye-bye.
The raven way